to have a stellar faculty with us today, including a distinguished moderator, Professor Dr. Stephan Schill. He is a professor of international and economic law and governance at the Faculty of Law of the University of Amsterdam, where he leads research on issues of international investment law, investor-state arbitration, and comparative public law. He is also editor-in-chief of the Journal of Rural Investment and Trade and ICCA General Editor. In that capacity, he oversees the production and development strategy of the ICCA Publications I've mentioned earlier. And with that, all that being said, please join me in welcoming Professor Schill. And Professor Schill, thank you so much for being with us today, and the floor is yours.
Thanks a lot for this general introduction, and I'm really honored to be able to moderate this session here on legal research and legal research strategy in international arbitration cases. Now, legal research, of course, as in any field of legal practice, whether it's domestic or international, is really key. So law determines the parties' rights and obligations and the power of arbitrators and domestic courts. And knowledge of the facts, of course, is crucial, but so is knowledge of the law. So this is a bit the starting point of this entire session. Legal research then is key to knowledge about the law, and it empowers lawyers to devise successful legal arguments and strategies for their clients to be successful in an arbitration case, or for an arbitral tribunal to provide a convincingly reasoned decision or award that will withstand both the scrutiny of domestic courts and ideally be enforceable worldwide. Many skills in international arbitration and also in international arbitration research are classical legal skills. So you need to be able to identify issues, you will need to be able to find the right rules, apply them, and come to a conclusion. Contract interpretation similarly is key. But legal research in international arbitration also differs from much of the research that you may be accustomed to from a domestic legal setting. And there are two main differences that I would like to highlight, and that I think this session is also geared towards highlighting. The first difference is that the sources in international arbitration differ. So it's not only or principally legal sources from one domestic legal order, so the standard setting that you would find in doing legal research on a question of domestic law, but the sources are really much more varied and broader. So it's often multiple domestic legal systems that play a role. It's domestic law and international law. It's soft law. It's comparative law that may become relevant in international arbitration, and also the role of doctrine and writings of scholars may differ greatly from whatever you're used to from a domestic context. So the sources, in one word, differ greatly to a large extent from what you would be accustomed to in the context of domestic legal research. Second, the resources differ. Now, classical research tools in civil law are usually commentaries. They're hardly existing in the field of international arbitration. In common law, it's databases these days that help you find out case law and that help you find out whatever is actually binding precedent in your respective legal system. So, but those databases and also the commentary, to the extent it exists, is often not specifically focused on arbitration-related issues, but they're really court-focused with respect to a specific domestic legal order. And these two differences, so differences in sources and differences in resources, are what we're going to explore in this session with two highly qualified speakers. The first one is Mona Wright. She's a senior professional support lawyer with White & Case International Arbitration Group based in London. She's qualified as a barrister and has been working for many years as counsel on a range of investment treaty and international commercial arbitrations. She's going to speak principally on what I would call the sources differences that we see with respect to legal research in international arbitration cases. So with that, let me hand over to Mona.
Thank you, Stephan. And thank you also to the Young ICCA co-chairs for their very kind invitation for me to speak to you all today. Now, as Stephan has already explained, you won't be surprised to hear that legal research in practice can be very different to academic research or what you would do in the context of your legal studies. An essay on an aspect of arbitral practice and a research memo to underpin a submission in a case will differ greatly in purpose, style, and focus. Research in international arbitration is also, as Stephan has explained, very different to research into substantive law, even when both are carried out in the practical context. This applies to both commercial and investment treaty arbitration, but for the purposes of today's workshop, we'll be concentrating on commercial arbitration. So over the next 15 minutes or so, I'm going to share with you some of what I like to think of as golden rules or strategies for efficient legal research in the international commercial arbitration sphere. I make no apologies for the fact that I'll be echoing what Stephan has already said. He's already highlighted some of the really key considerations. And you may already be familiar with a lot of what I'm going to say, or will find it obvious and common sense, which is great. And in that case, hopefully this will be useful confirmation to you that you're taking a sensible approach. But there may also be things I mention which will give you alternative perspectives or serve as helpful refreshers. As a starting point, what you look for and how you present your research, of course, depends on the parameters of your task. It's crucial that you establish these parameters at the outset so that you avoid wasting time researching things you don't need to and present the outcome of your research in the most effective way. And this is all quite different in the legal practice context than in the context of when you're doing your studies. Also, typically as a junior associate, your work will be subject to review by someone more senior. So you'll want to ensure that they will need to make as few amendments as possible before passing on your work to the ultimate recipient if that's a different person. So before you even start to do any research, the things you need to know include: how much time do you have for the task? If you're working to a tight deadline, then you know you have to avoid the temptation to go off on tangents and down interesting legal rabbit holes. Time is money, specifically your client's money, so you shouldn't waste it. You don't always need to go into in-depth analysis. Depending on the situation and timing, sometimes you only need to come up with a quick and dirty, broad brush answer. Who is the research for? Who are you sending it to, and who else will it go to down the line all the way to the ultimate recipient? This will have a major bearing on both the focus and the presentation of your work. If you're being asked to set your research out in an advisory note for your client, it's likely to be a shorter, snappier product with fewer legalistic details and citations and more focus on practical analysis and ramifications than if the document is intended to be a detailed research memo to be shared with other members of your counsel team and which might form the basis of your legal submissions to the tribunal. And what is the ultimate purpose of the research? Are you being asked to look for support for a particular proposition? For example, the other side have applied to the tribunal to join a third party to the arbitration. We object to this and are looking for support for our submissions to this effect to the tribunal. Is it a relatively contained query? For example, whether orders from emergency arbitrators are enforceable in particular jurisdictions? Or is it a more open-ended inquiry where you might need to trawl through the wider universe of information on the topic, such as what circumstances might generally support grounds to challenge an arbitrator? This all affects both the scope of your work and potentially the sources you may need to consult. So now that you know what the scope and context of your research task is, the next step, if you haven't done a huge amount of practical arbitration research before, is to manage your expectations. A truism that every arbitration practitioner understands is that clients don't come to us for answers to their problems. They come to us for solutions, and answers and solutions are not the same thing. I mention this because one of the key things to bear in mind when you're asked to research arbitration issues is that you're not always going to find a neatly packaged answer to your query. So an important consideration for you is to manage your own expectations about what you might find in the course of your research and where. You need to be prepared to be open-minded and think outside the box compared to researching substantive law, particularly when considering the sources you might use. So what does this actually entail? Well, I'll give you a few examples. First of all, arbitration practice is international, and international is a real watchword. What this means in practice is that, unlike when you're doing a piece of research on substantive issues of law or even civil litigation procedure, when you're doing research in arbitration, as Stephan has already said, you will frequently need to look beyond the laws or norms of a particular jurisdiction. Depending on the issue in question that you're looking at, you may have to take into account the approach taken to the issue not just at the seat of the arbitration, but also in the legal cultures or jurisdictions that each of the tribunal members is from, and which might influence their view of the issue. The substantive law of the underlying contract or dispute might have a bearing on the parties' expectations and may be a different law to the law of the seat. So might the legal cultures or jurisdictions that the parties and their counsel are from. Each of these jurisdictions and participants may take a different approach to the issue you're looking at. It may even be that the issue you're trying to research is which law applies in the first place before you even get to the content of that law. A typical scenario may be where the parties have chosen the substantive law of jurisdiction A to govern their contract, have specified a city in jurisdiction B as the seat of any arbitration, but they haven't expressly stated in their contract which law governs the actual agreement to arbitrate. Now, you could be asked to research which law that is likely to be, but the answer to that question may not be the same under the law of jurisdiction A and the law of jurisdiction B, and your research may need to cover both scenarios. What this also illustrates is that in international arbitration, there is no such thing as one single correct way or approach to almost anything. Don't make the mistake of assuming that because you've previously experienced particular approaches or preferences, that that's how everyone must do it. You need to be prepared to grapple with concepts and preferences from beyond the jurisdiction you're based or qualified in, or indeed your own previous experiences of arbitration. In a similar vein, watch out for confirmation bias in your research. Remember that for every example you find that backs up your instinct or view or the proposition you want to advocate, there's probably an equally valid or compelling example to the contrary. A particular trap I've often seen people fall into when they're starting out relates to the use of soft law instruments which offer guidance on commonly encountered procedural issues. Now, don't get me wrong, these are fantastic and can carry a lot of persuasive weight, particularly some of the better known or more heavily used sets of guidelines developed by respected organizations such as the IBA or ICCA. Just be aware that they don't always represent a single universal viewpoint. And of course, sometimes you're going to be trying to find support for the opposite position to that espoused by a particular soft law instrument. You then also have the complication that, unlike when you're looking at substantive law issues, there is no formal hierarchy of sources in international commercial arbitration. As you'll all know, the general position is that arbitral awards do not bind third parties and lack formal precedential effect. A judgment of the Supreme Court of a given jurisdiction may automatically take precedence over the judgment of a lower court on the same issue, but an arbitral tribunal is not automatically obliged to follow a decision made by another arbitral tribunal, not even if the same people sat on both tribunals. So just because you have found an example of where a tribunal has decided an issue in a particular way, that doesn't lay down a general rule and doesn't mean your tribunal will follow suit. Of course, this is also assuming you can even find such an example. Remember that international commercial arbitration awards are not always publicly available. There are examples of publicly available awards out there or redacted excerpts of the tribunal's legal reasoning from an award, but many more will be kept confidential. And also note that even if an award is published, it's unlikely to cover in detail all of the procedural issues that have been dealt with throughout the proceedings. So it might record that a particular application was made by a party and the outcome of that application, but not the basis of the tribunal's decision or the arguments put forward by the parties. And one tip I have for you here on awards is that in some jurisdictions, if a party needs to seek assistance from the domestic courts in relation to an arbitration, for example, if you're applying to set aside an award or to enforce it or to challenge its enforcement, any copy of the award lodged with the court as part of those proceedings may become accessible as part of the public documentary record for the court proceedings. So that's one way in which some otherwise confidential awards might be accessible in some jurisdictions, even if the arbitration was seated elsewhere. Another aspect of international arbitration that you need to bear in mind, and that again Stephan has touched upon, is that, as you well know, it's a field about which a huge amount is written, not just by academics, but also by counsel and arbitrators. And of course, a person can wear all three hats, and Professor Schill is a case in point. Of course, I'm not just talking about books. There are many excellent arbitration-focused journals and other publications, and also a wealth of ad hoc thought leadership materials that are regularly published by people who are interested in the field or who work in arbitration. The average national arbitration law or set of procedural rules tend to be pretty short and sweet, and of course awards lack precedential value. So it's commonplace for practitioners to cite academic and quasi-academic writing and articles in support of propositions they're advocating, much more so when it comes to procedural issues in particular than you'll be used to seeing when researching substantive issues of law, where you may frequently see citations to leading textbooks, but not so much to articles and much less ad hoc writings by fellow practitioners. Soft law instruments, guidance from bodies like ICCA, and empirical studies such as the Queen Mary Whiting Case International Arbitration Surveys are also frequently cited. So sometimes Google can be your best friend when it comes to arbitration research. You also need to be aware that there may not be a single standardized piece of terminology for what you're after. For example, if you're looking for writings on document production, some authors from some legal cultures might refer to it as disclosure rather than document production, or discovery or exchange of documentary evidence. Similarly, if you are researching something on challenges to arbitrators on the grounds of impartiality, you'd need to ensure you also captured relevant materials on bias, apparent bias, manifest lack of the qualities required for an arbitrator, and so on. In a nutshell then, as I said, you need to be open-minded and try to view things through an international or transnational lens rather than a domestic one. And a great practical example which really showcases all of this is evidentiary issues. As some of you may be aware, in some jurisdictions, evidence is considered to be a substantive legal issue, but other jurisdictions treat evidence as a procedural issue. And often the law applicable to the arbitration or the procedural rules chosen by the parties will give the tribunal a significant degree of discretion in determining evidentiary matters. Some even provide that tribunals are not bound by the strict rules of evidence of any particular jurisdiction. A common research task for a junior associate is to look at how the tribunal in a given arbitration might approach a particular evidentiary issue. Now, sometimes that could be a straightforward task, but at other times it could be a risky strategy indeed if you conducted that research purely from one perspective. Let's say, for example, we're in the middle of a document production phase and there are some sensitive documents which we think are legally privileged so that we don't need to produce them to the other party. What might you need to take into account if you were researching this? Well, you need to ascertain, of course, which law applies to evidentiary issues and what approach it prescribes, and how much discretion the tribunal has under the relevant laws and procedural rules. You'd likely also have to check the position in the jurisdiction in which your client is based to see if they'd have had an expectation that privilege would attach to those documents in the event of a dispute arising. And what about counsel? What's the position in the jurisdictions where the counsel are based and under any applicable professional conduct rules? And what if there's no specific privilege rule in one relevant jurisdiction because there is no requirement there in the first place to disclose documents to an opponent? If the tribunal has complete discretion, might any of the arbitrators be more or less likely to be sympathetic to a particular approach based on their own legal background or culture? You'd probably also look at soft law sources such as the IBA guidelines or Prague rules on taking of evidence. And, well, you get the idea. So, you've thought about everything I've just said. You know exactly what it is you're being asked to research, for whom and for what purpose and in what time scale. And you've got some idea of the kind of sources you might tap. You're almost ready to start researching. But before you do, I wanted to share a few final practical tips with you. First, as you are probably aware, there is no single one-stop shop when you're researching an arbitration. There are, of course, some fantastic research resources out there, such as the online Clue arbitration platform, which provide a huge range of resources in one place, and you'll be hearing more about Clue shortly. But you may need to look at a variety of sources, even on the same platform or database. So something really obvious, but that will be invaluable when you're dealing with really meaty research tasks, is to track your research. Keep a note of each source you look at, a bullet point or two on what you found, and whether or not it was helpful. This is key to make sure you don't miss anything and also avoid duplication. When you're really up against it, you've worked your way through what feels like 1,000 different sources and don't think you've quite yet found what you're looking for, you can consult those notes and both reassure yourself that you have been thorough and stay efficient by avoiding needlessly checking the same things again. It also helps when the senior associate asks you, oh, did you check in XYZ? And you have the answer at your fingertips. And sometimes it can be better to start broadly with your research and then filter and hone what you find. This is particularly the case if you're not massively familiar with the issue you're looking into. You may, in those circumstances, find it more helpful if, instead of searching for a very exact phrase, you make your search terms a bit broader and see what you capture, then drill down from there. And finally, don't worry if you can't find something exactly on point. There is a good reason why every arbitration lawyer's favorite answer to any question is, it depends. Sometimes what you will really be looking for is not the perfect or even the correct solution per se, but rather support for a plausible one backed by persuasive arguments. That may be the ultimate goal of your research task. Now, I hope you will have found this brief canter through a few strategies useful. And with that, I'll hand back to Professor Schill.
Mona, thanks a lot. I think there are two things that you said that really rang a bell with me. The first one is something that I also regularly tell my students now, specifically on investment law, but the same would hold true for international arbitration more generally, is that there's hardly ever only one and hardly ever one right and correct answer. And that, I think, points you not only to sort of differences in sources, but also then lead you towards actually a need to be able to operate the skills you need to find and develop possible different answers to an issue. And you can be sure that if an issue or a dispute ends up in an international arbitration, there will be 1, 2, 3, potentially more views on that issue that actually caused the dispute. The other one is the rabbit hole that you were speaking about. Now, that's, of course, sort of my domain. So we're paid for actually rabbit holing ourselves into a legal issue that may not be particularly efficient, and we spend too much time thinking about it. And I think that is not the reality for practicing lawyers. You have to be efficient and effective. And again, that leads me to the answer or to the other issue, which is you need to know the resources and you need to know how to handle them efficiently and effectively. So thanks a lot, and hopefully come back for more. Young ICCA is doing a really great job with these webinars. Thanks a lot.